Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Appeals just about costs. It's a tricky area. What we're going to chat about today, guys, is a recent decision of the New South Wales Court of Appeal where a party appealed a costs order that was made. Okay, so the first instance decision, remember, if we get to the Court of Appeal, we need to have a first instance decision. Okay. The first instance decision was in the District Court, and it was related to a really fiddly real estate transaction that went bad. A number of pieces of litigation were heard together, and the plaintiff, who was eventually successful in our relevant piece of litigation, actually ended up spending the best part of 9 days sitting in a hearing dealing with issues that were totally irrelevant because there were so many knotty issues threaded together. We're not going to deal with all those knotty issues at the moment, but the short thrust of the point is this. The plaintiff made a broad range of claims against the defendant and was successful in relation to one of them, and so was successful in the proceedings. And so, due to UCPR 42.1 that we talk a lot about, costs follow the event. So the person who wins gets their legal costs. So this plaintiff, who was successful in the proceedings because of his or her or its success on this particular point, gets a costs order. Now, the success in the proceedings amounted to about $60,000. And the costs incurred because of the mess of all these different bits of proceedings, including the 9 days where the plaintiff did nothing, amounted to something like $400,000. And so the defendant decided that it would appeal this costs order on the basis that the plaintiff only succeeded on a little bit and not on the wide variety of issues that the plaintiff raised. You can understand why the defendant might want to resist having to pay these costs. And so the matter comes before the Court of Appeal. Now, in order to get the Court of Appeal engaged in an argument about costs, you first need leave to appeal. And the reason for that is that public policy reason is that courts don't want parties incurring legal costs in arguments about legal costs. And that, I hope you'll agree, stands to reason. What happened in this case was that the appeal court crunched through the various pieces of litigation, crunched through the demanding way and occasionally bizarre way it strikes us on reading it, way the district court litigation was conducted, and found that the defendant's argument on appeal was no better than arguable. And because the defendant's position on appeal was no better than arguable, it was not granted leave to appeal. So it has to sit down and stick with those cost orders. It's tough times. What I hope that quick little sketch, that quick little tour reveals for you is I might not say dangers, but I might say difficulties on appealing a cost decision. Thanks for joining me today. Look forward to grabbing another coffee and another case note soon. Cheers.